Mr. Harvey versus Mr. Facey. In 1893, a misunderstanding over a telegram led to a landmark contract law case. Mr. Harvey was a wealthy businessman. Inside an office, Mr. Harvey sits at his desk and is carefully writing a telegram. Mr. Harvey was eager to purchase Bumper Hall pen. He writes, "Will you sell us Bumper Hall pen? State the lowest price." Harvey smiles, hands the telegram to a courier. The courier hurries through the busy streets to deliver the message. So, to initiate the purchase, Mr. Harvey sent a telegram to Mr. Facey, asking if he is willing to sell and at what price. The courier rushes out to Mr. Facey. The message was swiftly delivered to Mr. Facey, a composed businessman. Mr. Facey reads the telegram. He strokes his chin thinking, "I wasn't planning to sell, but if I did, I would not accept less than £900. Mr. Facey, though responding to it wouldn't mean committing to the sale, then picks up a pen. Mr. Facey received the telegram and responded with the lowest price he would consider, but with no intention to sell. Mr. Facey's reply telegram said, "Lowest price for Bumper Hall pen, £900. The telegram is sent back to Mr. Harvey. Mr. Facey simply stated the lowest price, but did not make an offer. The courier reaches Mr. Harvey. Mr. Harvey reads the reply and smiles confidently. He assumes the agreement and immediately writes back. Mr. Harvey excitedly writes back, "Great. I accept your price of £900. The deal is done." Believing Facey's reply was an offer, Harvey assumed the deal was sealed. He hands the telegram to his assistant. The assistant hesitates and asks, "Sir, do you think this means he agreed to sell?" Mr. Harvey with full confidence says, "Of course. He stated his price. That means we have a deal. Send it off immediately." Believing that Mr. Facey's response was an offer, Mr. Harvey assumed the deal was sealed and attempted to enforce the sale. The reply was sent to Mr. Facey through a telegram. Mr. Facey frowns, shaking his head as he reads Harvey's response. He says firmly, "I never agreed to sell. I only stated the lowest price." Mr. Facey writes a final telegram rejecting the sale. Facey clarified that he never made a formal offer to sell. Mr. Facey clarified that he had only provided a price, not an actual offer to sell. This misunderstanding led Mr. Harvey to take legal action. In a grand courtroom, Mr. Harvey and Mr. Facey sit on opposite sides. Lawyers argue passionately. The judge speaks firmly. A legally binding contract requires a definite offer and a clear acceptance. Simply stating a price does not constitute an offer. For a contract to be valid, one party must make a clear offer, and the other must accept it without ambiguity. Mr. Facey's response was merely a statement of price, not an actual offer. The court ruled that Mr. Facey's response was merely a quotation of price, not an offer. Since no formal offer was made, there was no acceptance and no valid contract. The court ruled no valid contract existed. This case set an important precedent in contract law. A quotation of price is not an offer but an invitation to negotiate. For a valid contract, there must be a clear offer and explicit acceptance. A price quote is not an offer. A contract needs clear offer and acceptance.